Welcome. So, today we're going to talk about something pretty wild. It's about how one single car crash way back in 1971 completely flipped the script on the rules of the road for every single one of us. This is the story of the duty of care and the learner driver. Okay, so let me start by asking you a question. Just think back to your first time behind a wheel. You're nervous, you're fumbling with everything. Should a total beginner in that situation be judged by the exact same standard as someone who's been driving for 20 years? Is that even fair? Keep that thought in your head because it's central to everything we're about to get into. You see, this whole story doesn't kick off in some fancy courtroom. Nope. It all starts with a simple, friendly favor, a driving lesson between friends that would have consequences nobody could have seen coming. What's so wild is just how normal this all was. You've got Mr. Nettleship, who agrees to teach his friend's wife, Mrs. Weston, how to drive. It's only her third lesson, so she's an absolute novice, just practicing the basics. And then, during a simple left turn, everything just goes completely sideways. In that split second of panic, and I'm sure a lot of us can relate to that feeling when you're first learning, Mrs. Weston gets the pedals mixed up. She means to hit the brake, but instead her foot slams down hard on the accelerator. The car just shoots forward, mounts the curb, and smashes right into a lamppost. In the crash, her instructor, Mr. Nettleship, ends up with a really nasty broken kneecap. And that injury, right there, is what transforms this friendly favor into a huge legal battle. And just like that, what started as a simple lesson becomes this massive lawsuit, one that was going to redefine what responsibility even means on our roads. And this brings us right back to that fundamental problem. Who is responsible when a learner driver, someone who by definition is gonna make mistakes, actually makes one? So the arguments in court were fascinating. On one side, Mrs. Weston's defense was basically, come on, you can't expect a beginner to drive like an expert. I'm learning, my standards should be lower. And that makes a lot of sense, right? But the other side's argument was all about public safety. They argued that to protect everyone on the road, the standard has to be the same for every single driver, no matter how much experience they have. So the court had a really, really tough decision on its hands. So now we get to the trial itself. And really, it wasn't just Mrs. Weston on trial here. It was the entire idea of what it means to be a learner. The court was at a major crossroads. Do they create a special lower standard for learners, like a sliding scale of responsibility? Or did they decide to hold everyone, from the person on their first lesson to the 20-year veteran, to the exact same high standard? The answer to that question was going to affect literally everyone who gets behind the wheel of a car. Now, logically, you'd think you should probably be a little lenient with a beginner, right? It seems only fair. But the law, well, let's just say the law had a very, very different perspective. And that brings us to the verdict, a decision that created a principle that stands to this very day. One standard for all. And this quote just perfectly captures the court's cold, hard logic. Lord Denning, one of the most famous judges in English history, said this in his judgment, and it's a zinger. The learner driver may be doing his best, but his incompetent best is not good enough. Wow. Talk about blunt, but it gets right to the heart of the ruling. So what the court decided was that Mrs. Weston wasn't going to be judged as a learner. No. She was going to be judged by the standard of a reasonably skilled and competent driver. The fact that it was only her third lesson, legally, it didn't matter one bit. This case is so important because it cemented this legal idea called the objective standard of care. So what does that even mean? Well, it's a duty to act like a reasonably careful person would. And the key word there is objective. It's not about what you can do personally. It's about what an ordinary, competent person should do. Your personal skill level doesn't enter the equation. So you might be asking, why are we digging up a car crash from 1971? Well, because its legacy on our roads today is absolutely massive. Okay, so this ruling is so important for a few big reasons. First, public safety. It creates one predictable high standard for everyone. Second, legal certainty. The courts don't have to waste time trying to figure out how skilled each individual driver is. It also underpins the entire car insurance industry. It's how they calculate risk. And most importantly, it protects all of us by making every driver accountable to the very same duty of care. So if you take one thing away from this, let it be this. The second you turn that key and pull out onto the road, in the eyes of the law, you're not a beginner anymore. There's just one standard, and every single one of us has to meet it. And that leaves us with a really interesting final question to chew on. This single standard makes sense for drivers, right? For public safety. But is it fair in other professions? Think about a junior doctor doing their first surgery, or a new chef in a crazy busy kitchen. Should they be judged by the exact same high standard as a seasoned expert? Where do you think we should draw the line?